Hello and welcome to another episode of the Revenue Revolution, sponsored by Joint Flows. Today, we have the privilege of being joined by Marina Khawaja, legal advisor to SaaS companies and startups worldwide. How are you?
I love that introduction. I'm great, thank you. How are you doing?
I'm good, thank you. I'm good. Marina is also a good friend. Has been very helpful to us up until today as well. So it's great to have you here. Paint a little bit of color for our listeners. Tell us who you are.
Okay, so Hitesh said it perfectly. I am a legal advisor to tech startups, predominantly B2B SaaS companies. This is where I met Hits and Mick many years ago at Yieldify, where I was the head of legal, and Hitesh and Mick were the stellar salespeople. And they were just a pleasure to work with. And since then, we've been great friends and have worked together. I have worked with them on their amazing startup Joint Flows, and happy to help them make a success in terms of legals. And actually, I'm here to help, kind of highlight how legal can be a key player in driving the success of a startup.
Absolutely. And I think that's probably a good starting point as well. So you mentioned how legal can play a key role for the success of startups as well. And I'm sure there are common challenges that startups experience. Can you talk a little bit about this?
Yeah, so that there are various things that you need to consider when you're starting a company, and I think legal should really be a big driver and at the forefront of any founder's mind. So I'll just kind of touch on the sorts of things that you should be thinking of. The first would be intellectual property. That I think is one of the first things that founders think of when they come up with an idea. How can they protect their IP? Are there rights that need to be registered? Are you working with software developers or individuals who have some ownership or right to some of the intellectual property in your idea, and what you can do to ensure that you secure those rights? So whether those are contracts for IP assignments, whether that is registering trademarks or any patents to new ideas or new technology. It's important to talk to a legal advisor or a solicitor about securing those rights adequately. One of the reasons why this is such an important consideration is obviously IP gives you a competitive advantage. And also in the long term, if you're thinking about fundraising, investors will be very interested to ensure that their investment is secured and the IP is secured in the idea.
Yeah, great starting point, actually. And for a lot of our listeners out there who might just be embarking on this journey to begin with, how long do you think that process typically takes from saying, hey, I've got a little bit of intellectual property over here and I need to protect it, to, hey, we've got it protected?
It depends entirely what type of intellectual property it is that you're securing. For example, if it's copyright exists, the right exists at the time of creation. So you just want to be evidencing the time that you created it and that you are the creator. If it's trademarking something, then there is a process that you need to go through. Which can take a little bit longer. If you're patenting an idea, just the consultation with a legal advisor, initially searching to see whether there are any patents which are similar. That does take some time. However, it's not something that needs to take you a long time, to be honest. It's just, something that you need to keep in mind.
And is this something you do on an ongoing basis, or is this something that you do to start with and then you don't have to think about that anymore?
Yeah, that's a good question, actually, Mick, because as you guys will know, from the inception of an idea to the completion of an idea, there are many iterations. So, I remember when you guys came up with the idea of Joint Flows and you came to me and it looked very different to how it looks now. So this is something that you need to be considering as you go along, and just ensure, any changes or iterations, or if you use a new developer or an engineer for a particular part of your platform or product, you're securing those rights as you go along.
Yeah. And so Is the idea that this phase should be completed before you take anything to market, or can this be run concurrently?
It can be run concurrently. You can backdate contracts. It's not best practice, but it can be done. It's just something to be conscious of to ensure that you have covered all of the IP, any possible IP that there could be in your idea or in your platform or your product.
It's quite scary because when you start, as an entrepreneur, you don't necessarily have a legal background, or you don't even know what you don't actually know, like what you don't know. Sorry. So like it's a massive black box. What are the places you can go to outside of an individual where you can find such information about, have you thought about doing this? Have you thought about doing that? Like a checklist. Is there a place?
Yeah, well, off the top of my head, I can't think of a specific resource. Maybe something that I can share with you after. However, I mean, Google is brilliant. There is the answer to every question there. There's countless guides on what kind of things you need to be considering. Or even ChatGPT, I'm sure like you guys and many listeners use it, a simple question to say, what are considerations around intellectual property protection as a startup founder I should be going through or I should be thinking about. So, it's good just to have like an initial checklist, and then as you delve into it further or have the resources, because I know obviously financial considerations are key when you're a startup founder. When you have the resources to look into it properly, it's something to consider. But one thing I would say that doesn't necessarily cost very much is if you do have other individuals who are helping you to develop your IP in any way, is making sure their contracts have adequate IP clauses in them.
Yeah. To me, I think there are three big area when you speak about legal protection when you start a company. There's the IP protection, then there's the how you set up your shares and your equity so that it's long term and you're not in a position where if someone leaves then you lost a lot of the company. And the last one is about how do you contract new clients as well, because it's just as complicated to have a good foundation where you can just add stuff as you develop the product, because you might be tapping into a new data set or a new aspect of the software does something completely different.
Yeah.
Where do you feel like startups are getting it wrong on the legal side when the early days?
So I do think IP, this is why I mentioned it first, is I do know a lot of startup founders who get very excited about their idea, work with individuals, develop the idea, and then there are no contracts in place, or the contract did not focus on IP assignment or transfer or licenses. So, they're working with individuals, and it can go south because they don't necessarily own the IP. And it may not be that there is a disagreement between them and the individual who developed it. It may just be when it comes to fundraising, they don't have a contract in place to say, I own this IP. And then investors are not necessarily as keen to invest. Secondly, you mentioned when it comes to equity. So for founders, this is a big consideration. Equity, how it's distributed, and even going forward, how
you vest them.
Yes, exactly. So vesting is an issue, and then also equity schemes, so employee schemes going forward, if you want to be granting tax incentives in the form of share options. Having good legal advice around setting this up from the outset, I think, is very important, because, a lot of startup founders will say, hey, come on board and work with us. We don't have any money right now, but we will give you some equity. And this is what it might look like. But they don't necessarily have the share scheme in place. They don't have any documents around it. And so it's quite a vague conversation, and it can cause disputes going forward. There can be issues. Another thing to consider is equity dilution, and how that will work when you do get to a funding round or a fundraise. So how will your equity dilute, and how will other individuals, other shareholders in the business, how will their equity dilute at a funding round? Because I think people don't necessarily do those calculations from the outset, and it can come as a surprise when there is a fundraise, the impact that it has.
Yeah, it's crazy. Like, I think, like, to me, that's where we had the least knowledge when we started the company. Like, we're not coders, we don't have any technical background, but I felt like we were so much, without you, I think we would have failed like week 2, basically.
Yeah.
No, that we had the idea, just couldn't even phrase it.
It's very true.
Let alone putting it in legal terms. So yeah, it's really I think you kind of have to start that process even before you start coding anything, because it's a steep learning curve, and it's a little bit scary. It's a little intimidating. So yeah, get equipped, get advised, and then you should be fine. But you need to go out there proactively.
Yeah, absolutely. I felt like we were always on the big risk until you reviewed anything for us. Like, I don't know, are we doing this right? Like, should we do it? Are we just screwing ourselves over here? What are the kind of common factors that are overlooked when it comes to share options in particular? So I know we spoke about equity and the dilution of it and how founders can sometimes be surprised, right, in terms of what that looks like. But when it comes to share options, what do you see as being commonly overlooked? Because those are typically, I guess, when you're trying to get employees in, they're coming from an option pool. So what's kind of advice and recommendations over there?
I think, yes, that is really key, because there's a lot of mystery around share options. I think that employees who come on board don't necessarily have a lot of knowledge about how it works in reality. I think that comes from the fact that there are different types of share option schemes. And also, share options in the US operate a bit differently to share options in the UK. So if you have an EMI scheme in the UK, there are certain statutory rules that apply that don't necessarily apply in the US. One of the key differences, I would say, between US and UK share options is, in the US, once share options have vested, and that means those are options that you are able to exercise in the event that the company is purchased or there is an IPO, for example. Once they have vested, they are yours to exercise, or they are yours basically as part of your compensation package. In the UK, it doesn't work in the same way. So you may have vested share options. So you have a portion of your options which are vested to you. However, if you are to leave the company before there is an exit, and that exit will be defined in the share option documents, you forfeit the rights to those share options, essentially. So that if you leave, let's say you have spent 3 years at a company, and you leave before there is an exit, let's say someone comes in and buys the company, you have forfeited those rights, and then therefore it's not necessarily compensation earned in the same way. And if it was considered compensation, it would then be taxable as income, and that's the distinction. So it would fall under different statutory rules in the UK. So I think that first is key, because I think in the UK there's surprise often when employees come to move on and they lose out on those share options which they feel they are entitled to. So I think it's very important from the outset maybe to create like a one-pager information document of how your share option scheme will operate, and to provide that to individuals during the hiring process, maybe, so they have a bit more information, especially before you have a share option scheme set up. I think that would be very helpful. It just comes down to lack of knowledge and information around, a lack of clarity around it, I would say.
Yeah, it makes so right though. It's quite overwhelming, isn't it? And I know we already said it, but I feel like if we didn't have you on our team, we probably wouldn't have a clue.
I don't know. That's too generous, Hits. I know that you made an excellent makeshift legal counsel.
Just for our clients. Yeah, just for our clients, just so you know, it is all sense checked and approved by our legal advisor as well.
Yes, that's right. But I mean, there's a lot to be said, Hits. I think a lot of it is common sense and just knowledge. Once you have the knowledge, you just need common sense.
Yeah. And how do you what's your experience with the legal side of things, but on commercial conversations? So when you're negotiating terms with clients, like what's the best way to create a good relationship between a commercial team and a legal counsel?
I really think there is a lot to be said about having a collaborative approach with any stakeholder. So that could be with a commercial team or a non-commercial team. So having a collaborative approach rather than a combative approach, and being very transparent and open. So I know, legal priorities is a big, it's of importance to especially commercial teams. And the more transparent you are to say, this is what's on my list, this is where you fall on my list, and keeping communication constant and open. That's the best approach I have found. I know in the past, if I have become inundated and overwhelmed, sometimes my communication has slipped with individuals that I'm working with, and then that has been detrimental to my relationship with them, and therefore, how well we work together. So I think that communication and transparency are key, and being as collaborative as possible.
Who do you think should own? There's a little bit of a plug for joint flows implicitly, but if joint flows aside, like who do you think should own the responsibility to break those silos internally? Do you think this should be with the CEO? Do you think this should be with the CRO, the CFO, like where, or the legal counsel itself? Whose responsibility is it to bring light to these things?
So yeah, that is a tough question. I think a lot of it ends up falling on legal, which shouldn't necessarily, because legal, aside from just the commercial aspects, legal have so many other things to deal with. So the corporate side of things and just regulatory compliance in general. A lot of what legal does is firefighting, and then it's difficult if you're always firefighting and always, bogged down in sales, to be proactive and consider, forward-coming risks. So there's a lot on legal's shoulders, and as it's not a revenue generating function of a business, there's not a lot of resources that are allocated to it. So I don't necessarily think it should sit with legal, but I do think, as I said, collaboration between all teams, there is a lot to be said of that. And I think, not to plug joint flows, but as I've seen the evolution of joint flows and what it has hoped to do. And it started off more, as kind of like more of the focus was on legal contracting and transparency around legal contracting, and where it has evolved to, it's just, I cannot think of a way of working that wouldn't involve joint flows, because it seems to solve all of those problems, which is, the working in silos, the lack of collaboration, the lack of communication, the lack of transparency. So everything I mentioned, it just covers all of it.
And I think sorry, it's there's when you're in sales and you're trying to close deals, you kind of feel like you're entitled to legal priorities. And when we speak, obviously we're now kind of on the other side. We're kind of trying to sell to legal counsel as well as the rest of the team. But you speak to some of those stakeholders, and actually anything that is linked to commercial contracting is the tip of the iceberg. Like there's so many more things that they're looking after, like partnership programs, acquisition stuff, like dealing with tenancies. So like when you're renting a place and all of that, and that's really time consuming.
Yeah, exactly. So the things that I was talking about, litigation, IP rights, you're having to think about data protection compliance, you're having to think about, employment law considerations, employment law compliance, the corporate side, like you said, employee share options, fundraising. So all of these things, and it usually falls on in startups, or let's say scale-ups, because startups don't usually have a dedicated legal resource. It often falls on one individual, and it's a lot to project manage, and therefore, managing sales prioritization, it's just another thing to do. So one thing that would be better is I think legal has a key role in the sales process, but I think that sales need to take a bit more ownership of that process and all of the stakeholders. And that's where Joint Flows is so great, because it allows them to do so a lot easier. Because I know for you guys, often it can feel like herding cats. You grab one person and get them to work on one thing, and then you're trying to grab another person to work on another thing, and trying to get everyone to do that by the deadline, and everyone to kind of be streamlined in their approach. So, legal, we do try to help in facilitating smoother deal closings, doing the risk assessment and mitigation, and all while trying to do it quickly and then doing it for multiple deals. So, there's quite a lot to consider. And, it's very important, and on top of that, for legal to be very commercial in their approach as well. It's very easy as a lawyer to get a bit academic about contracts and be like, oh, well, this actually legally, if I'm being very strict about it, this should say this, but you're never going to get the deal signed.
Yeah, that's what I love about you, Marina. Like, that's very unique to you, I find, that you give an answer, but you also give like an element of like risk level. So it's like, okay, well, we can do this or we can do that, and here is the risk if you do this, and here's the risk if you do that. So then it becomes a collaborative effort to find the agreement, like basically the middle ground, where I think sometimes the expectation from salespeople is to say, well, legal is going to make the legal call. And actually it's not that binary. I think there's something in between.
And I think both of us have worked with legal teams who sit on both ends of the spectrum, and the ones like you are a lot better to work with, as you said, a lot more collaborative. And one of the things that I wanted to talk about as well is when we're talking about contracting, once again, if you're early stage or you're scaling up, what are the main, when we're talking about client contracts, what are the main kind of things that you should consider? What are the main talking tracks or the talking points within that contract that you need to ensure are watertight?
I would say initially, from the outset, you need to have a really good contract. It needs to be sound. So before even the talking points, your contract has to be very good. You want to make sure that you cover everything within your contract, and you're not having to you want to try and cover as much as possible in your contract, and not be putting things in an order form or an email or something that you hash out, so your deliverables should be ironclad. There should be no question about, who is going to do what, by what timeline. And there's often a question of risk allocation. I think that sales probably, I've worked with some really great salespeople. You two are like probably the best. And I think it's because you're very clued up about legals, and I think that, and risk. And I think that helps a lot. I mean, there was a time when I worked with Nick, and he said, you can just, put this clause in white ink.
White ink on white paper, they'll never see it.
It works like a treat every time. And no one prints anymore, so you can't actually tell.
Yeah, exactly. No, Mick never did that. I never allowed him to do that. And there's no part of the Joint Flows contract that's in white ink.
No, absolutely not.
But I think and then this leads into what we can talk about later, which is like ethics in sales practices. But having your contract covering as much as possible is key. And also having a balanced contract. It's very easy for suppliers to try and draft a pro supplier contract, and all of the clauses are in their favor and not really in a customer's favor. But what happens then is, you just go through a really lengthy negotiation process where they're saying, hold on a second, the indemnities are so imbalanced. You have all of the protection and we have no protection. There's just no point in a contract like that. I mean, I could easily draft a contract which will just protect you and leave the buyer to assume all the risk. But no one's going to sign your contract. So I think that is key. Being very aware of, that balance of risk is important. So other talking points, I think, which is very important for a tech business that handles customer data, is data protection. So having a sales team who is clued up about data protection law, at least the basics. And I think a lot of them are these days. It's hard to make a sale without being aware of that kind of thing. But drawing attention to data protection compliance and how your business in particular is compliant and what you do to protect customer data, that will go a long way. So I think that's very important as well.
Yeah. And we see like a lot of startups, the end game is typically to exit and get acquired. But then also what happens when you're a startup moving to scale up and you start to get bigger on your way to the exit is you find that you have a lot of contracts which have deviated away from the terms that you set out to begin with. A big part of the acquisition, or, you know, even when you go to raise funds, my understanding is understanding what that looks like. You know, how much have you deviated away, for what customers, to what value? What's the best way of keeping track of this, like from the very beginning? I know I've heard of companies who did an absolutely horrible job of that, and then it's a big task to be able to aggregate all of that in a sensible, digestible way. So what's your recommendation in terms of how do you do that from the offset?
Yeah, so I've seen it done in different ways. And, you know, having in mind, being very proactive, I think is key. Being reactive to anything in business. Obviously, there are some things you can never really plan for, but being reactive to legal considerations, I think usually ends up being detrimental or creating a lot of work in the long term. So, you know, like I said, if you have a good contract as a baseline, that's a good start. And then you wouldn't need to be deviating too much from it. It's good, I would say, to have a contract playbook to say, okay, this is what our contract says. This is our second line of negotiation. And if you want a third line of negotiation. So at least you know, these are the positions we will always be taking. You don't really want to bespoke too much. And then thirdly, you want to have some way to be keeping track of that proactively. What you don't want to do is have hundreds of contracts. And I've been in this situation before. You don't want to have hundreds of contracts where you're having to go through each contract to see, you know, where have we deviated. Now, there's a lot of tools that are available now to keep track of this kind of thing. However, there's still an exercise where you need to be uploading those contracts and then still going through any legacy contracts. So proactivity is key, but Joint Flows does this perfectly.
It wasn't a leading question. I know
it wasn't a leading question because it is something that everyone needs to think of. But this is what I mean, you know, Joint Flows has thought about all of these things for each of the stakeholders to help project manage so many different parts of this process, which is brilliant. But so maybe you can tell us then how Joint Flows does that quickly.
Well, as you said, I think it's about keeping a record and making it available. But keeping a record is not enough. Like, you need to be able to understand the context of when the record was made. So when you're dealing with high volume, and that's my experience without pitching Joint Flows, the struggle comes around how much knowledge you keep and how much knowledge you document. Because keeping it, if it's in your brain, then there's an argument that when you leave, then the knowledge is lost. Same if it's offline on a Word document or something like that. So you're right, there's a more and more the contract management system, you know, is growing. That vertical is growing massively, because when you look at the complexity of a sales process, you do end up staying a very long time proportional to the overall duration in legal negotiations or security questionnaires, which I think is kind of overlapping with all the legal aspect as well. So I felt like, I think one of the frustrations we had when we started thinking about Joint Flows is it felt like every negotiation we were going into as like closing new deals, we kind of felt like we were starting from scratch again. You know, like, okay, what did we receive? What's the take here? Should we have a meeting, speak about the risks? And then actually, when you've got tens or like hundreds of clients already signed up, you've probably seen it all, like in different shapes and different formats. But overall, as you said, like, there's a fallback, and the second fallback and the third fallback you can probably predict, you know, without having to do too much work. So thank you for plugging join flows.
Yeah, just to be explicitly clear, all those fallback options can be documented within joint flows as well, and that's where the acceleration comes from.
Yeah.
Sorry, carry on, Mick.
Yeah, I was gonna ask Marina, because there's a lot of external like like constraints that are happening, GDPR, compliance, AI, the fact that you've got more and more competitors, the fact that companies are merging. How often do you feel like you should proactively go into your terms as a supplier and review what's there, so that you're not firefighting when something comes up? And I'm thinking about these kind of like general laws that are being deployed.
Well, as a legal advisor, we obviously will try to be forward-looking when it comes to any changes in the law, any new regulation or guidance that might be coming in. So it's very rare that there'll be a huge change in the law that would have the kind of impact where you would need to change your terms and your business practices and not be aware of it coming. So I wouldn't necessarily say you want to be iterating your contracts frequently, especially if you want to have standard terms. You don't want them changing constantly and then having to keep track of, lots of different versions. But you want to be quite pragmatic and also proactive in what your terms contain. And sometimes you want to be drafting widely enough that a clause will encompass, coming changes in the law, and that you remain compliant, so that, compliance, you're compliant in your contracts, but compliance within the business you can deal with, without it impacting documentation or your relationship with your customer.
I've got a question, Hits, before you take over the obviously your software gets more and more integrated with time, and sometimes it gets more integrated so that you can embed that application into your software, but sometimes you use those external suppliers as a way to process the data that you capture. So, data controller versus data processors. Like, can you give us a little bit of light on this? Because it's always a big gray area I find in commercial teams.
Okay, so is the question, what's the distinction between a data controller and a data processor?
Yeah, and when do you become one versus the other? What are the risks to become one versus the other?
Okay. Just so you know, I feel like I know the answer to this, but I'm not going to embarrass myself.
No, wait,
in case I get it wrong.
Let's hear it.
No, you tell us. Actually, yeah, it would be good to hear what you think it is.
Wait, what if I got it wrong?
If that matches, that's okay. We're all friends
mouse
here.
Always putting me in it. Yeah, as well as the millions of listeners, so no pressure. So, the distinction between the data controller and the data processor is the processor doesn't necessarily own the data, but more that their platform or software is, how do I put this without saying the word processing? That data is just going through the platform instead. So at no point do they actually control it. So they don't actually put the data in or take it out. It's just going through it. Whereas the controller of the data is someone who owns the data, I guess. And then that data is then going through the software and being processed.
That's why we've got you, Marina. It's like you can't.
I can't articulate it.
No, I know you know what it is in your brain, and it's hard to say.
That's very polite.
No, I understand. So that is often what people think. So the distinction between a data controller and a data processor lies with whether you can use that data for your own purposes or not. So that's where I think, you're talking about ownership of data. A data controller will have access to data and be able to use it in a way where they kind of have the freedom to use it for their own purposes, obviously within the constraints of what the contract says that they can do. A data processor will just be processing the data, so using it or doing something with the data to do something they have been instructed to do, so not for their own purposes. So a customer can supply, as a data controller, can supply you the data, and you will do something to that data for them, for their purposes. So that's the distinction.
where do you draw the line? Sorry, it's a lot of specific questions, but
Oh, that's okay.
these are the things where you should be fully trained when you're a salesperson about how you actually have the first line of like managing the objections before involving your lawyers, because I think once you've learned them, you can give an answer a little bit almost as good as Hitesh did. Maybe not just as good. Maybe
We'll never reach that level.
Guys are too kind, so let's carry on.
where do you draw the line between you being a processor and then being and you using sub processes?
Yeah,
that's quite tricky as well.
So, I mean, there isn't a line to be drawn necessarily. So, you know, in what I have just said, as a processor, where you are doing something to that data for a customer who is the data controller, if there is part of that service you're delivering which you cannot do yourself, you have not developed yourself, you can use a third party who will be termed a sub-processor to then deliver that service. Again, you're not doing it for your own purposes. It's not you know, an operation or a function that you are doing for yourself. It is to deliver the services for the customer still. However, as the processor, you bear the risk of using this sub-processor. So your contracts will allocate the risk to you. You have decided to use a third party, and therefore you are responsible for their actions as well. If they were to breach, if there was some sort of breach around the data or the delivery of the service by this third party, you are still liable.
Yeah. So that's the client's responsibility to go and then do due diligence on what that sub-processor is doing.
The clients or the suppliers?
The clients.
No, it wouldn't be. So yeah. So essentially what would happen is you have a customer, they would like joint flows to process their data. Joint flows might use a third party in the delivery of its service.
Yeah.
The customer will be vetting joint flows with data security questionnaires and you know, checking your contracts are compliant. And then joint flows has an obligation to vet its third party sub-processors to make sure they are compliant, because ultimately joint flows will be liable for its sub-processors' actions or inaction.
Mate, we have a sub-processor list if you wanna have a look at it later.
No, I know. But that's the kind of when you're in sales and you're exposed to all these questions, it's the end of the quarter. You don't come up, you know, against those questions every day. So it's like once, twice a quarter. It's scary. You're like, oh man, actually we're using, I don't know, like Amazon or like whatever, Looker, and because their AI is better than it's not our case, but you might use a better processing system that then brings the data back into you, that then shows the data to the client. And in my career, I was like, am I responsible for these guys' terms as well? Like, or should I bring them to the table to negotiate? It was very, I don't know, I overthink a lot, as you guys know, but it's scary.
No, it can be confusing. And this is why I think, you know, we were talking about legal driving the success of a startup. I think one of those things is with training. So training of the sales team in particular, and having regular training as well, where there is a change in the law. But I do think that data protection training and training around the contracts is very important. And I think that is the difference between a team that has, you know, better selling practices or more transparent selling practices, because they're more knowledgeable and therefore they're able to say, hey, you know, this is what we do and this is what we don't do. An issue that you come across is, you know, sales individuals who aren't very knowledgeable in, let's say, data protection, and then they make promises that the company just can't deliver on. And then, you know, when it gets to the legal stage, and there are changes to the standard terms which don't make sense to, let's say, the data protection clauses, it's because the sales individual did not have the training necessarily. It's not, you know, that they wanted to be misleading. They just didn't have the information.
Yeah, I know some salespeople, if they're unsure, they just say yes. So yeah, probably
exactly.
not the best thing to do.
Yeah. So you want less of those instances where they're unsure.
Yeah. One of the things I wanted to ask you as well is security questionnaires, like an absolute nightmare, right? So when you especially as a salesperson, when you're getting to the end of your fiscal period, whether it's the quarter or the month or whatever it might be, and you think you're going to sign this contract, and often a lot of salespeople haven't mapped out the process. So now they've got the security questionnaire, and then somebody comes knocking on your door and says, hey, Marina, I've got this security questionnaire. It always ends up going to legal. And then it's not just legal who answers it, right? There's multiple resources you use internally to populate that questionnaire, but it always sits with legal to orchestrate it. What do you think is actually the best way of running this process? Because I see it happen all the time. And I almost feel a little bit bad for legal, because they're just giving this document and saying, here you go project manage that and let me know when it's done, which doesn't really make that much sense.
Yeah. Oh, I'm glad we have some sympathy. So I think, I've said the word proactive a lot. And I think it's really important. So you talked about mapping out a process. It's so important to be proactive and map things out and be prepared. Because in that way, when things come in, you're ready to deal with it quickly. It will shorten your sales cycle, and it will just make everything a lot less painful. So I think from the outset, knowing, okay, there's going to be contract negotiation, there's going to be a security questionnaire, there's going to be, questions for product, involving these people from the outset, introducing them to the correct people on the buying team, and having everyone involved from the outset, I think would really help. And I would say it's incumbent on sales to manage that process, rather than, if you end up dumping it with legal. We've spoken about what is on a legal counsel or legal advisors list. So if you're going to dump your entire, sales process on them, it's just not going to get done in the timeline you want it to get done. It's just not possible. Being proactive, forward planning, and getting everyone involved, telling them, this is where we're going to be needing you, so that they know and they can plan ahead in their own, diary and their own priorities. That would be the best way to deal with it. And guess what? Joint Flows does that perfectly.
Yeah,
that is true.
Your deal, your problem. Like, you have to be able to manage that.
Exactly.
Absolutely. Well, we are just about out of time, Marina. It's been an absolute pleasure
already
to have you on. I know it is absolutely flown by. We do have a wrap-up question, which we ask all of our guests. Through your whole career to date, what is your best memory and why?
Oh, that's really tough. Firstly, because I have a terrible memory and don't remember things very well. I don't have a best individual memory. I have met so many of my close friends and great people along the way throughout my working life. So my best memory is just like meeting and working with these individuals, and you two are included. I'm so glad that we've I'm so glad that we've stayed friends, since our time at Yieldify. I think it's about, 5 years ago now. And it's really nice to see like each of those individuals, where I've met them and where they have progressed to and where they're working to today. Like, I love seeing people, set themselves goals and reach those goals. So, it doesn't really answer your question very well.
No, it's a good answer. So you're saying me and Mick hounding you and coming and sitting next to your desk until you did something for us.
I loved it.
Isn't top of the list. Awesome. No, that's a really good answer. Appreciate it. Well, look, Marina, it's been an absolute pleasure having you on the podcast. This has been the Revenue Revolution podcast, sponsored by Joint Flows. Until next time, thank you very much.
Thank you.
Bye-bye.
Bye.